Illinois didn't just pass another gun law. They went all in. The Protect Illinois Communities Act banned the AR-15 completely. It also outlawed any magazine over 10 rounds, shut down all future sales and transfers, and forced every legal owner to register their rifle with the state. This isn't a proposal or a campaign promise. It's already in effect. If you legally bought your AR-15, you were suddenly treated like a criminal unless you registered it. And if you didn't own one yet, you were completely shut out. The penalty for not complying is serious: a felony charge, up to 3 years in prison, and a $10,000 fine. Governor J.B. Pritzker signed the bill into law in January 2023 and called it one of the strongest gun safety measures in the country. But the reality is different. Illinois has more than 1.2 million registered gun owners, and somewhere between 300,000 to 500,000 AR-15s already in civilian hands, all of them now caught in the middle. The ruling that rocked Illinois. Just weeks after Trump secured re-election in November 2024, a federal judge in Illinois shook the ground under the state's sweeping gun control law. Judge Stephen McGlynn struck down the entire Protect Illinois Communities Act, the one that banned AR-15, limited magazine sizes, and forced legal gun owners to register their rifles. And he didn't hold back. He called the law unconstitutional and pointed straight to the Second Amendment. In his ruling, McGlynn explained that the AR-15 is protected. Why? Because it's in common use. It's owned by law-abiding Americans, and it's used every day for legal purposes, especially self-defense. He said the state failed to show any historical tradition that supports banning firearms so widely used by responsible citizens. And without that, the law simply can't stand. The judge pushed for a permanent block on the ban, but legally that injunction only lasted 30 days. When it expired, the ban technically snapped back into effect. Illinois officials wasted no time. Attorney General Wam Raoul celebrated and promised to keep fighting for the law in court. State leaders thought they had bought enough time by dragging the case out on appeal, but they didn't expect what happened next when Trump took the fight to the states. In June, Trump did something no president before him has ever done. He sent the Department of Justice directly into Illinois to take on the state's AR-15 ban, not to defend it, but to fight it. Let that sink in. The federal government, under Trump's direction, walked into a state courtroom and stood shoulder to shoulder with gun owners. This wasn't a campaign rally or a talking point. This was real legal action. The DOJ filed an official statement of interest, a move that allows the federal government to step in when a case raises major constitutional questions. Attorney General Pam Bondi signed off on it herself, making it clear this administration would not sit back and watch states trample on the Second Amendment. To really understand how big this is, consider this. Obama never did it. Biden hasn't done it. Even Ronald Reagan, often praised for being proud, supported the 1994 assault weapons ban after leaving office. What Trump just did is on a whole different level. It's not just bold, it's historic, and it could change the future of gun rights in America. The facts that shatter the ban. Trump's DOJ isn't walking into court empty-handed. They're bringing the Constitution and the numbers to back it up. Their legal argument is grounded in 3 major Supreme Court cases: Heller, McDonald, and Bruin. And together, those rulings say something simple but powerful. You cannot ban a firearm that's commonly owned and used by law-abiding Americans for lawful purposes. That's exactly what the AR-15 is. Between 20 to 50 million of them are in circulation across the United States, making it the single most popular rifle in the country. To put that into perspective, Ford has sold about 40 million F-150 since 1948. There could be more AR-15 in American homes than the most iconic truck in history. And the numbers don't stop there. The U.S. has an estimated 1 billion detachable magazines in circulation. and nearly 500 million of those are standard 30-round AR-15 mags. That's not fringe, that's mainstream. Industry reports show AR-15 sales have skyrocketed by over 200% in the past 10 years. Today, 1 in every 5 guns sold in America is an AR-15 style rifle. That's 20% of the entire market. So, when Trump's DOJ steps into the courtroom, they're not arguing theory or opinion, they're putting hard data on the table. And that data crushes the idea that these rifles are somehow rare or outside the scope of the Second Amendment. How states are trying to cheat the system. But here's the part most people miss. States like Illinois have figured out a sneaky way to work around the Supreme Court's rulings, and they've been getting away with it for years. The trick is in the definition. Instead of banning the AR-15 outright, they use old language from the 1994 federal assault weapons ban to twist how it's classified. They say if your rifle has a detachable magazine and just a couple of certain features like a flash hider, a collapsible stock, a pistol grip, or even a bayonet mount, then it's no longer a regular rifle. Suddenly, it becomes an assault weapon under state law. Some states have gone even further. Just one cosmetic feature in one key can reclassify your firearm completely. But here's the truth. None of those features change how the gun functions. Not one of them alters its rate of fire, power, or performance. A bullet fired from a collapsible stock travels just as fast as one fired from a fixed stock, about 3,200 feet per second. The Bureau of Alcohol, Tobacco, and Firearms has said it clearly. Cosmetic features don't change what a firearm actually does. Yet some courts are still buying the argument. They're treating how a gun looks as more important than how it works. And that flies right in the face of the common use standard the Supreme Court has already laid out, why these bans just won't die. Here's what really frustrates gun owners. Even when a judge rules that a ban is unconstitutional, the fight doesn't end there. In fact, that's when the games begin. States like Illinois know exactly how to stall the process. The moment a federal judge blocks their law, they immediately file an appeal, and that appeal puts the brakes on everything. And here's the trick. While the case crawls through the courts, the ban stays in place. That delay tactic can buy states 2, 3, even 5 extra years of enforcement. During that time, gun owners still can't buy AR-15. Dealers can't sell them, and existing owners are still forced to register their firearms under threat of felony charges. It's like the judge's ruling didn't even happen. Court data shows the average gun rights case takes anywhere from 3 to 7 years to reach a final decision. That means states can enforce laws that have already been declared unconstitutional for nearly a decade just by playing the waiting game. That's exactly why Trump's DOJ move is such a big deal. The pressure that changes everything. By sending in the full legal power of the federal government, Trump's administration is applying pressure that states can't ignore. They're not just fighting back and they're speeding things up. The DOJ's involvement makes it harder for states to delay, stall, or run out the clock. And if this case makes it all the way to the Supreme Court, it's game over. With the Heller, McDonald, and Bruen decisions already on the books, legal experts say Illinois doesn't have a leg to stand on. And if this ruling falls, it could trigger a chain reaction across 7 other states with similar bans, including California, New York, New Jersey, Maryland, Delaware, and Washington state. This isn't just another legal battle. It's the most aggressive move any president has ever made to defend the Second Amendment at the state level. The outcome could reshape gun laws in America for an entire generation. Will this reach the Supreme Court and put an end to AR-15,